Thanks for all your all's work, guys. I really appreciate it.
Yeah.
And Aaron, do you want to give me the heads up when you want me to start? Just say.
Sure. Yes, I will. I will. Hi, everyone. Good afternoon. I think we're waiting for just a few more folks, so I'll give everybody one more minute and then we can get started. How about that? Okay, great. I think we have close to everybody who registered with us. So why don't we go ahead and get started? Just want to do a brief welcome. My name is Erin Donahue Keeler. I am the pro bono coordinator at the Georgia Justice Project, and I am so happy that you all are here with us this afternoon. This is our training to train legal volunteers to come and volunteer with us. So thank you for your interest in the Georgia Justice Project and for wanting to get involved in our work or get back involved. I know we have some volunteers who have already been with us before on the call, but wanted to refresh. So welcome to everybody. And we're going to start today. I'm going to kick it over to Doug Amar, who is the Executive Director at Georgia Justice Project and our fearless leader. So Doug, if you want to take it away.
So if you want to introduce the other parts of our team, since it's just four of us. Is that
yes,
right?
Great idea. Yes. So aside from myself and Doug, we have my colleague Molly Scott, who is the clinic coordinator here at GJP, and Dominique Madison, who is our intake coordinator and who is really the wind beneath our wings and runs the show. So grateful to everybody on the team for being with us today.
Thanks, Aaron. Okay, folks, my name is Doug Amar, and I'm glad you're here. Here's what I'm going to do. I have a few slides just to sort of orient you to the organization, the work, the issues, but the real technical details are going to be by those much more familiar, our trustworthy team here. So I'm just sort of giving you some overview. And since we have a small group and I have more minutes than I probably deserve to cover this, I would love to have some conversation or questions. If you have questions as I'm going through some of these slides, let me know, because we're small enough to have a conversation today. All right, so I'm making sure okay, so, there we go. So I have to push button. There we go. Okay, so the agenda today, we're going to just what we're going to cover. You can see talking about the issue, volunteering. We have two different kinds of volunteering for intake, for the clinic. Even the clinic has different pieces. We're going to cover basic records. We're going to talk about, we're going to have a break, and then we're going to shift to the clinic. This is a cool idea that I'm so glad our team has come up with, to not just do the training, but shift immediately to put your skills newly found into practice in helping serve people. So I'm really excited to see how this, you're our guinea pigs, I will say, but thank you for letting us try this new approach. And Molly and Aaron and Dominic, thanks for putting them together. Okay, so let me just jump into issues about the criminal justice system, and so you have a sense of perspective. One of the things we like to talk about is why we need your help so much is a new law we passed. It's went into effect a year and 2 or 3 months ago. That for the first time in Georgia's history, we finally have a direct path to get convictions off people's records. It's something we've been working on from a policy standpoint for years, and we finally got it across the finish line in 2020. That law we all refer to as SB 288 went into effect in January of last year. And as Dominique will attest, our intake went ballistic. I think it went up 3-fold in the last year, because now finally there's a way to get some of these convictions off the record. So this is the backdrop for why we need your help. And let me give you some more details about how this law works, if I can get my computer to work. There we go. Oh no, I gotta go back there. Okay. All right, so one of the biggest things about this law, as I mentioned, is it, for the first time really allows convictions to come off your record, and primarily misdemeanor convictions. though there is a path for felony convictions that have been pardoned. That's huge because as our work over many years has said that, and we know this, a felony conviction is the biggest barrier for reentry, in particular for employment. So having a path to get a felony conviction to be expunged / restricted or sealed, what have you, is huge. And as I mentioned, this law went into effect this last year. And we're terribly excited about it. And we've seen a huge uptick in intake all across our sort of platforms, whether they be the COB expungement desk or whether they be in restriction summits / expungement summits, or obviously here in the office. So a little more detail. The other cool thing this law did that in large part because of our work with both the Chamber of Commerce for Georgia and the Metro Chamber, is we've got added to the bill a very aggressive for really the country protection for employers who hire someone with a record. And that record it's just huge, and it's probably the broadest background protection we think is available that we can find maybe in the country. So it's a big part of what's making this law work. And we think that there's more of an interest from the private sector because of that as well. So that's part of the new law. But let me back up and say, okay, so that's one of the reasons we're here, is this fabulous new law that's making an opportunity for millions of Georgians that wasn't available until a year before that. So I like to use this slide just to talk about the system, so you have an understanding of the criminal justice system. Most everybody in the criminal justice system talks about it in thirds, so the front end, middle, and back end. And the front end is anywhere from policing all the way through the court system. That's in the red. The middle is obviously incarceration if someone is convicted, in the yellow. And then back end is everything from probation, parole, and of course, criminal records. Once you're out of custody, but the lingering impacts of the criminal justice system. On the outside of this arc, you'll see some numbers for Georgia. We have about 90,000 people, which is combining the first two buckets on the left, who are incarcerated. That's jail and prison. But what's really significant also is not just who's incarcerated, but who's under correctional control, which takes that number and combines it with those on probation and parole. And so in Georgia, we have about 500,000 roughly people, 527,000 people who are under correctional control. And that makes Georgia, by the way, the leader in the country, and we have been for a couple of decades, of leading the country as a per capita number of people under correctional control. And again, correctional control is jail, prison, probation, and parole. And then, of course, the 4.3 million, which has actually gone up since we made the slide. It might be in another slide. We're up to about 4.6 million, according to our friends at GCIC. 4.6 million Georgians, about 40% of the population, have a criminal record. And that means someone, as you'll learn a lot more about, who's either been arrested and or convicted. I mean, some of these, their fingerprints show up in the database from the state and the feds. That's what a criminal record is. And we have 40% of Georgians who have that situation. So these are some startling numbers just to frame what the need for this work. The next slide is about our work in the system, so to speak, GJP's approach, if you will. We work at every stage of this arc. The thing, well, I'll start with what's on the far left. Obviously, one of the reasons we're here, as already mentioned, is the policy work. We've actually been, this slide's even kind of old. We've actually changed 21 laws. We got to update this one. So we have 21 laws we've changed in the last basically 14 years. And the expungement law is one of them. We also got a very significant law passed last year around probation. But our work on that green arc, if you will, really covers every part of the criminal justice system. But our work is really grounded in direct service. And so the other boxes here, the red, yellow, and blue, are all about the doors into our office. Like, what is it that we do as an organization? And there are 3 different ways that we become somebody's lawyer. And when we serve somebody, that's the first part of what we do. That's the entry point, is becoming somebody's lawyer. And the first thing we do, we've done the longest, is this holistic criminal defense. We represent people. Everything we do is free of charge, but we represent people from the very beginning, pre-arrest, arrest, but through a case, a criminal case, all the way through the case, but also we follow the client into prison and back into the blue section into reentry. And that's sort of that's what we've done for 35 years, is that long-term commitment to people, not just resolving their case. The other door into our office, the yellow arc, is a relatively newer door. It's in the last almost 4 years now. I work at a new prison here in town, the only Department of Corrections, Georgia Department of Corrections prison inside the perimeter It's called the Metro Reentry Facility, and it's right off Moreland Avenue. And we've been out there for over 3 years, almost 4, helping remove barriers to reentry before people get out of prison, which is quite fascinating work. It's actually fueling a lot of our policy work. We can talk about that if you want to. And then, of course, we're really here today mainly about the blue bucket, and that is the criminal records bucket. And we've been doing that work as a standalone sort of feature for the last a little over 15 years or so. And that work is our biggest part of our work. We serve more people in that area than any other area, which we just refer to, you can call it record restriction, expungement, what have you. A lot of ways we do it, but that's what we're here to talk about today. All right, so this is sort of GJP's work writ large. And this slide will talk more about giving you some perspective of the numbers. And I like this slide just to say, we talked about incarceration, about 90,000 people in Georgia, with about 527,000 people who are under correctional control. That combines the first bucket plus probation and parole. But then if you said who has a criminal record, the number is even, you see the perspective. It's a huge number, and it's a big part of the population. And that's why there's such a need to work on this issue, because it affects so many people. Nationally, the number is about 25 to 30%, as high as 100 million people. Most folks put it somewhere between 70 to 100 million who have a criminal record in America. So this is not even just a big issue for Georgia, it's a big issue for the country. And the next slide, which I'm having, it's not, there we go. Okay. So one of the biggest impacts we see with a record is getting employment. In fact, we estimate about 90–95% of people who knock on our door for the last 15 years and say, I need help with my criminal record, or can you help me? It's because of employment. They want to get a job. They can't get a better job. They're afraid to apply for a job. They have applied for other jobs. They've been denied because of the record. A criminal record is and employment is it's a huge part of helping people not get back into the system. My team knows, I like to say, having a job or employment is like the antidote to recidivism. So if we can't get people jobs or help them get jobs, there's a high correlation between recidivism and unemployment. So we're always, as a society, I would think we want to help make sure people can get jobs, but a criminal record becomes a barrier. So some of these data points just sort of point to how much of a barrier it is in having a record, and the number of callbacks, and the compounded impact that having a record, if you're a person of color, if you're African-American in our culture, and you have a record, and you're looking for a job, it becomes even more pronounced. And again, we see that every day. You'll see it probably today with the intake we do, or the clinic we do today. So let me go to the next slide. If my computer will cooperate, good. So, but that's not the only reason, of course, that the criminal records is a barrier. It's one of the biggest things we see and the biggest needs, the felt needs, but housing is probably right up there. But we got into this work most deeply because of housing, a barrier for housing for folks with a record. But also we've done for years work on professional licensing, or getting deeper with that work, thanks to an Equal Justice Works grant and a lawyer who's wonderful working with us, and some, we can talk about that from a policy standpoint. Having a record can be a barrier to going to college. There's a large push now to try to change, even here in Georgia, the college applications that are done by local, state, and private schools that ask, often at the very, I have a son who's a freshman, and often ask him the very first, few questions. Have you been convicted of a felony when you're applying to college? And I think most of the schools in Georgia still do that. And there's an effort to try to change that, like a ban the box approach, if you will, to education. And of course, at the end of the day, it's people's dignity. I mean, we say it a lot. I've heard it said this way: no one wants to be judged or defined by the worst thing they've ever done. And having a criminal record often does that. It becomes the easiest thing to find out on the internet, and the most deleterious impact on someone's future in their life, their ability to just move on with their life. So we want folks to be able to live into their full promise, their full opportunity, and having a record, it can be, and often is, a barrier to that. So with that, Aaron, am I getting towards the end? I think I am. Okay, so let me stop there, and I'm a few minutes early, which is amazing for me, but I do talk fast. Talked about the work. I've talked about some of the issues, the numbers. Before I jump off and hand you over to the experts, any questions or comments from our very illustrious group here today? Well, if there's no comments or questions, because you all know this, or you're ready to dive in, you really want to get to the meat, and Molly and Dominique and Aaron are going to bring that. I really want to say I thank you so much for being here. I remind people, my team all the time, that I actually volunteered at GJP twice before I came on staff 32 years ago. So volunteering is a huge, Molly volunteered here, Dominique volunteered here, Aaron, we're leaving you out because you didn't volunteer, we hired you. Volunteering is a big part of what I think is important. And it's important to me, it's important to the organization. And more importantly, it allows us to have a bigger impact in the world. And with the opportunities that are out there and with the needs and people coming to us, we need you and our clients need you to make a bigger impact, to take these laws, to take this opportunity and make it real for people. So thank you so much for being here. And I saw there's one, I'm sorry if there was a question. Okay.
Doug, we do actually have a question that just came in through the chat box, so I'm going to read it. Could you explain a bit more about the employer liability protections? I think that's referencing SB 288 that came with the new law that you mentioned earlier.
So this is, I think this is interestingly, it's the law, even though it passed in the same bill, this part of the law is, I say buried kind of in the evidence code, I believe, not in the 37.3, I mean, not in the criminal records code. But here's my understanding, a couple of things. If you have a record and it was a non-conviction and or that record got expunged or sealed, then essentially that record is not eligible to be used in a court of law. Like the presumption is you can't even talk about it. Even if it's a conviction, even still, the requirement is on sort of the moving party, often that would, whoever the moving party is, to sort of make the case that it's relevant, that conviction is relevant to whatever the case is about or whatever the accused conduct is. So there's like this really presumption, a much higher bar in presumption that says this, you can't even bring it in, we can't talk about it. And there is a way to talk about it if it's very connected and if it's a conviction. But it just puts the onus back on the moving party, where at least my friends who have practiced in some commercial litigation have said, if there's some kind of dispute between companies or some kind of malfeasance or accident, they've said to me, one of the first things one side will do, the plaintiff side will do often, is ask for the criminal records of everybody involved. And that was just standard protocol in some discovery action. That is not allowed anymore. In fact, you have to jump through the court and say, well, here's why, or here, just so it's changing the presumption, it's changing the trajectory of when and how and whether those records can ever come into play. So that's my, having read it a few times, that's my understanding of the law. Aaron and Molly, is that your all's understanding?
Yeah, I think so. That's great.
It's a good question, and it's important. And it was one thing that a lot of employers, again, we want to get people jobs. We want to get people not go back into the system. Jobs is the way to do it. And if employers need more protection, we ask them, what do they need to hire our folks? And this is one of the things they've said. So we're hoping this change in the law will have an impact on uptick in hiring. Any other questions? Hopefully that's responsive and helpful. Thank you again. Thank you for being here. Thank you for all that you're doing. Thank my team for doing this today and all of your all's great work. And I'll be around if you need me. All right.
Thanks so much, Doug. We really appreciate your time being with us today.
Thank you.
Okay, I'm going to get going on a couple slides, just giving you a overview of the criminal records program and how we work with clients and volunteers. Aaron, let's see, can you get me to the next one?
Sure, yes, sorry.
Sorry, we're learning new Zoom features about sharing control, but it's
there we go.
There we go. Okay. So this, for our criminal records program, which is where we use our volunteer lawyers and paralegals, step one is training, which we're doing today. We also have training for our clients, for our potential clients, and that's called First Friday. And it's the first Friday of the month, and it's an overview of criminal records law in Georgia for the client, for the potential clients, and then there's an opportunity to discuss their particular criminal record and how they may qualify or not qualify. So then, step two is our criminal records intake. That is held once a week on Thursdays. And that is when a potential client meets with either a staff attorney or a volunteer and goes through their GCIC, which is their official Georgia criminal history, and gets information from them about how their record has been a barrier. That's still the pre-stage where it's not a GJP client yet. We do ask volunteers to participate in the intake, or we offer it as a volunteer opportunity, but with all these, there is as much hand holding and preparation as you would like. So I don't want you to get overwhelmed from the beginning. Then step 3 is when the intake notes, the GCIC and the client's application come back before our criminal records team, and they review the cases and determine which cases qualify under Georgia's law and which clients we're able to take on. Unfortunately, we cannot take everybody. We are definitely able to take a lot more in the past several years when we've had the clinic and volunteers, but there's that case review process. Then step 4, that client would either be assigned to a GJP staff attorney or assigned to the clinic. And the clinic is held once a month on the second Friday morning, typically, but we're trying something new today. And we really appreciate all of you that not only signed up for the CLE, but also signed up to take a clinic case afterwards. Then step 5 is repeat. We just kind of keep going through the cycle week in and week out and getting these cases resolved to the best of our ability. So with that, I'm going to turn it back to Erin, and she's going to talk about intake, and then I will talk to you about the clinic.
Thanks so much, Molly. And Doug mentioned this when we first got started, but we are a small enough group, and we really want this to be useful for you all and to empower you to feel like you could definitely come and volunteer with us. So if you have questions as we're going along, please don't hesitate. Feel free to unmute and interrupt us or put questions in the chat, whatever you're comfortable with. So I'm going to talk to you a little bit about our intake process. And so, like Molly mentioned, it happens every Thursday from about 9:30 in the morning till about 12:15 or so. Of course, we're in Eastern time, so it is all virtual right now. We're doing it over our conference lines, so that makes it a little bit easier for folks to meet with their 2 to 3 applicants. And the purpose is to really gather information from folks. So we're interested in knowing how their record has been a barrier to them, why they reached out to Georgia Justice Project, so that we can determine, how we might be able to assist them. So volunteers will get a link to files, to a file that has every applicant's documents and a set of intake meeting notes, which will guide the interview with the applicant. And then, of course, like Molly mentioned, we support you as much as you need. So we review all the documents with you prior to the meetings. We've even, been in on the meetings if folks want that for their first time or two, and we're available the morning of to answer questions. So when you sign up to volunteer, you'll get an email from me, which will be a little bit more in-depth than this example right here, but just generally speaking, it'll have the link and have the information. And so we actually created a demo file that I am going to pull up right now so we can look through all the documents together. So this is what the Dropbox folder will look like. You can see here there's the intake notes, which are those notes that you will take interviewing the applicants, and then a file for each applicant along with the time of their appointment. So when that person is supposed to be joining the conference line with you. So I'm just going to go into this folder here. So this is John Doe. He's our first appointment for our intake today. And you'll see that this is his application. So I'm going to try and make it a little bit bigger here for you all. But this is our GJP application that we ask folks to fill out when they apply for representation. So it just has basic contact information, information about the person. You know, we do have a mission of assisting folks who can't otherwise afford an attorney. So we ask them questions about their income and other sources of financial support. And then we ask just really briefly, just to get an initial sense of why they're seeking help with us. And, you know, we ask about their education, what their job situation is like. So that's what the first 2 pages of this document are. And then you'll see the next 2 pages will look something like this, which is something that we need from the applicant, which gives us permission to request a copy of their criminal history report. So that's what both of those 2 pages are. And then the next document that you will definitely have in the file is the person's criminal history report. So we are going to go much more in depth in how to read one of these in a couple of slides, but I just wanted to show you this example so that you can see, you know, okay, this is what it looks like. It's called a GCIC report. And you can see, you know, this first page is mostly disclaimers. And here's really where the meat of the person's criminal history starts. So again, we're going to practice reading one of these. I don't want you guys to be concerned that I'm scrolling through this really quickly, but just wanted to give you a sense of, you know, that's what's going to be in the file. These are the documents you're going to have ahead of time, so you have an opportunity to read through everything first. And then I just want to take some time now to talk to you about what the meeting notes actually look like. So there'll be 2 different versions, a Word document and a PDF. It's exactly the same thing. Just pick whichever file you are most comfortable with. And then I'd like to go through the questions with you now so that you can see what kind of information we really need. So again, what's most helpful for us is for our volunteers to be gathering information from the applicant about how their record has been a barrier to them. And the reason why we need this information is A, because it helps us determine who we can assist with their record, who we can actually take on as a client, but also it's information that we'll typically need to include in any pleading. So it gets us a head start on the actual representation piece if we're able to do that for somebody. So, you know, it's going to ask just a little bit of information from you and from the potential client. That's what PC means on that 3rd line there. Explain to PC why the info is necessary. It asks you to fill out here what type of GCIC you reviewed, and we'll get into that later, but it will almost always be a purpose code U. And then we're generally wondering what are their concerns about their record. And like Doug mentioned, the vast majority of folks come to us because they have had some sort of barrier to getting a job. So digging in here a little bit about what does that barrier looked like? You know, where are they at? Are they working right now? Are they looking for a job? Are they on hold of their job search until they can get their record cleared? Are they in school? What field are they hoping to work in? You know, what's their training background been like? And then this question in bold here has potential client been denied employment due to record. It's bolded because it's one of the more important questions. And this is something that we really are very interested in knowing about. Has somebody been denied a job or a promotion or something like that because of their record? And then it's really important during intake to get as many details about that as possible. So it's really helpful to know when they were denied, what was the job, you know, who was the employer, what was the position they were applying for, and things like that. And then for us to know if they received any documentation of that, which they are supposed to receive, but that doesn't always happen. And like Doug mentioned, we do have an attorney who is helping expand our work on occupational licensing. So we do ask if folks have been denied an occupational license because of their record. And then housing is probably the second most common barrier that we see when we're interviewing folks. So again, just wanting to get some information about the applicant. What is their living situation right now? Is this somebody who has had a lot of problems and bumps along the way, but they've landed at a friend's house or mom and dad's house or something like that? Or are they homeless? What's their housing situation right now, so that we can sort of gauge if we can plug in any of our social service supports for them and how urgent their issue is. And then again, this bold question, have they been denied employment because of their record? Again, or sorry, denied housing because of the record. So again, really gathering as many of those details as possible during that initial intake appointment. We also ask about child support because we have a lawyer on our team who assists folks who are facing some sort of consequence because they can't afford to pay their court-ordered child support. So perhaps they are facing jail time or loss of their driver's license because of this. So I usually tell the applicant, that's why I'm asking about their child support. To me, it could seem a little strange that we're asking about that and they've come to us for their record, but the two can be intertwined. So getting as much information as possible. Some folks are not going to have all of this right at their fingertips. And I will say that our intake appointments are pretty short. We usually schedule 30 minutes for them. So, if somebody doesn't have their DCSS and case number right in front of them, you don't need to pause the intake to go have them go and get that for you. We can always get that from them later. And then it's helpful for us to know some background about what they've done about their record and sort of where they're at. So, for many folks, we are their first stop. We're the first place they're coming to for help. And so that's great. We love to know that. But others have really tried to clean up their record on their own and been unsuccessful for whatever reason. So it's helpful for us to know sort of what steps they've taken on their own. And if it's sort of a situation where we're going to need to come in and try and, advocate for them in court for something. It's also important for our purposes to know if they're on probation or parole, or if they have an active pending criminal case. Usually, if the answer to this is yes, we can't assist folks, but not always. So there is no need to tell someone that we won't be assisting them if they answer yes to this question, but it is something that we need to know about. So that's why we ask that question, and then just getting as many details about that as possible. We also ask you to go over any arrest that might be missing the disposition on the record. And again, that might not make much sense right now, but once we go into what a record looks like, hopefully that'll become a little more clear. But again, it's important for us to know that information because what can be done for their record really depends on the disposition or the outcome of the case. And then it's really helpful for us to know if they have an urgent matter related to their record. And usually this is a question that's really targeted to the volunteer. We're asking the volunteer to answer this question because most of our applicants would answer yes, that they have an urgent matter. And of course, it is important to them, but we are really trying to, sort of pinpoint those folks who are about to be evicted if they can't clean their record up, or they have a job offer that will expire in 5 days if they don't clean their record up. So that's what we are hoping our intake interviewers will capture in that space. Then we have space for any other notes in this document. And you will see some vestiges of when we were in person. Also, there's a possibility we may be back in person at some point this year. So, we haven't changed our forms, but just as an FYI, it used to be that folks might bring documents into the intake appointment, or we might give out informational documents to them during the intake appointment. But we're not really doing that virtually, of course. So, so if you're conducting your intake over the phone, just disregard those 2 questions. And then, a common question at the end of the intake is, well, when will I hear back from Georgia Justice Project? And our intake lead time, that step 3 that Molly talked about, the case review, it can really vary. We're anywhere between 6 to 10 weeks. So when I check in with you before your volunteer shift, I'll be sure to confirm what you should tell folks as far as what the lead time is. And then it's helpful for us to know sort of what other supports the person is receiving, if they've been through any sort of programs. All of that information is useful internally. And then again, information that the courts and prosecutors will be interested in knowing about, and that can be beneficial when we're actually doing the legal work for the folks. And then this is the last page of the intake interview notes. And this is the space where folks can capture any information that the applicant shares. So I just want to highlight a couple of things here. So, and again, I know this might be a little confusing since we haven't done a deep dive yet into actually reading a record, but I think to just generally keep in mind that we at Georgia Justice Project are going to have a copy of the person's criminal history report. So if you miss notes or count convictions incorrectly, that's not a big deal because we have the record that we can refer back to. What we really need you to capture is information that is not on the person's criminal history report. So for instance, this question about, have they ever been arrested or convicted for any offense outside the state of Georgia? We can't see that on their Georgia criminal history report. So we do rely on these intake notes to get an idea of if there might be any out of state history. And then another question is, have they used first offender? And again, that might not make sense now, but we will talk all about first offender in the second half of our training today. And then we have this space to capture notes. So again, what we ask folks to do in this space is not transcribe all of the information from the criminal history, because again, we have that. So it's really a space to capture any notes for folks who are going to tell you information that's not on their criminal history. And that can be almost anything, right? I mean, we've had folks say, okay, this arrest that you're seeing from 1993, that was not me. I was never arrested. This chart is a great place to make those notes. Okay, so I just want to pause briefly right there to check in and see if there are any questions about that. Again, I know some of it is maybe a little bit like a foreign language since we haven't actually dived into the criminal records portion yet. But any questions generally about the intake files? Okay, great. Please feel free to put them in the chat if you don't want to unmute. So that's what the folder from Dropbox will contain. So I am going to minimize this and go back to my PowerPoint here. Okay. And just some information on how to be a great intake volunteer. All of our volunteers are really wonderful, but this is things that you could do to be a standout volunteer. Reviewing the documents ahead of time is really helpful. We find that one of the biggest barriers can actually be just accessing the files. In this day and age, it's just so complicated, and different firms and corporations have all sorts of different technology in place. So right now what we are doing is like I said, sharing the files via Dropbox, but we have had plenty of folks who can't access Dropbox for whatever reason. So we can almost always find a secure workaround, but we need to know that ahead of time. So please, 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 even if you don't have time to read all the documents, just make sure that you make some time to open the link and see, okay, I can actually see the documents, I'm good. It's really important during the interview to take thorough notes and just to be clear with folks. So we are, asking that you would treat our potential clients like you would treat a potential client that came to your office or your organization seeking services. Introduce yourself, explain that you're a volunteer with Georgia Justice Project, and explain that this is the applicant's initial intake interview. So what that means is that this is a chance for us to get to know them before we make a determination about whether or not we'll be able to assist them as a client. Unfortunately, we try really hard, and I know Dominique and her team do the best that they can to explain to folks the process, but unfortunately, miscommunication and misunderstandings happen, and sometimes folks come to us thinking, okay, on their intake day, they'll walk away with a clean record, and that's not what happens. Our process is lengthy, but also the process for if somebody is a client is lengthy too. So just sort of setting the expectation up front that's what they're looking at. So you are going to go through their criminal record with them, sort of cycle by cycle, and you'll see what a cycle is when we dive into that. But we're hoping that you will ask if the information is accurate to the best of the person's recollection. And then being sure to ask if there's any information that's not on the GCIC. So again, anything that's out of state, or do they have any cases that aren't appearing on their GCIC report? It's really important to be as specific as possible. And we know that sometimes these things have happened a long time ago. So, we don't want you to badger any of our applicants, but the more information we can have, the more powerful petition we can file for them. It's also helpful to tell folks to start gathering materials. For example, if they have any job denials or employment, housing denials, to gather that information up to send to Georgia Justice Project. We do hope that, like I said, you would treat our applicants like you would treat somebody coming to your law office seeking services. And then the other way that you can be an awesome volunteer is to give your notes back to me quickly. We don't need them the same day, but definitely within the week is the most helpful. Feel free to, print out those note-taking sheets and handwrite notes and send them back to me handwritten if that's the way that you like to do it. Just if you do it that way, please make sure I can read your handwriting. Otherwise, feel free to type up your notes. All right, I knew Doug went through quickly and now I'm going slow. So I'm already at my time for these slides, but I'm going to go through the next ones pretty quickly. I think the most intimidating or fearful factor that volunteers have when they come to do intake is, it's like, am I going to have to explain to this person like what can be expunged from their record or not? And the answer to that is no, we don't expect you to do that at all. Like I said, you'll have an opportunity to review every client's file with staff before the intake appointments. So there may be situations where we're able to advise you, okay, this one's really simple, here's what the person needs to do. But 9 times out of 10, you are just gathering information. GJP staff goes through every single file after the intake appointment, and we also follow up with every applicant and give them resources and information. And again, we're making sure to ask if there's anything incorrect or missing, or what the biggest barrier for them has been. Some folks, like the next question asked, will come to us with 10 cases or more on their criminal history report. So in that situation, we're really just trying to get the big picture for those folks. You're not going to have time in a 30-minute interview to go through case by case if somebody has more than 10 cycles on their report. But we're trying to see big picture. Is it the most recent case? Is it the more serious cases? What is coming up on a background check for them? So this happens very, very, very rarely, but so I don't want to alarm you, but I just want to give you some confidence that if you are meeting with somebody who is in some sort of crisis mode or has some sort of urgent matter, just get us involved. We have resources. Like we've said, GJP attorneys will be available sort of on call during intake or even on the line with you. We can address any emergencies that might arise. Additionally, we have a whole team of amazing social workers at Georgia Justice Project that can get involved if somebody is in crisis. So do not feel like that is something you would have to handle by yourself. It's not. And again, just want to reiterate that this is an extremely rare scenario, so do not be alarmed. And lastly, what if something comes up and I can't make my scheduled slot? Listen, we're people, we understand things come up. Molly and I both have kids. We know COVID has been crazy. Schools are shutting down left and right. So we get it, we understand. But when you sign up to do intake for that day, we are counting on you to do it that day. So just let us know as soon as you can. Obviously, you know, things happen, life happens, and folks get sick. And if you can't let us know ahead of time, we understand. But it's really helpful for us that if you know, oh gosh, I just got scheduled for a deposition and I have this intake, just let me know as soon as possible so that I can try and find a replacement for you. Okay, and this is just a little bit, want to sort of switch gears and talk to you about, these are GJP's values. These are our values. You can read a little bit more about them on our website. But this is really, these are the values that we hope that you will reflect to the folks that you are meeting with, right? So they are not necessarily in order of importance, but I do think respect is really far up there. We know at Georgia Justice Project, we are operating within systems that are not set up to respect our clients or their dignity. So in all of our interactions, and you know, when you come to volunteer with us, you are the face of Georgia Justice Project or the voice of Georgia Justice Project to applicants and clients. So we hope that your interactions will, you know, just reflect their humanity back to them. And we hope that you will see them as whole people and not defined by their case or their past. You know, we meet with folks who maybe made one mistake, but we also meet with folks who maybe made a lot of mistakes, might have a lengthy criminal history. But we want to go into those intake meetings and into representation with them with an open mind and keeping respect at the forefront of all the interactions that we have with our potential clients and our clients. And we recognize that, you know, we're going to be coming from very diverse places. You know, you likely have not lived the same life that our clients or our applicants have. So we just want to respect and value the diversity that they bring, and really, you know, respect that in our interactions. And many of these values, you know, go hand in hand with that. So we hope that you'll be compassionate and, you know, exercise humility and optimism, which can be really hard to do, right? If you're meeting with somebody who has a lengthy history or, you know, somebody who we might not be able to assist. But we find that, you know, even just being a listening ear for somebody and really recognizing their dignity can give them more than you know. So don't discount that. All right, I think that is the end of my slides for now. I have once again gone over, but if folks have questions about any of that, please feel free to interrupt us or put them in the chat. But for right now, I'm going to kick it back over to Molly. Molly, I'm going to try and give you control of the slides now, hopefully.
Okay. So in transition, you know, Erin was talking about volunteering at intake, which is the, you know, is the initial stage. Then we also have volunteering opportunities at our clinic, which is the direct representation. And this is what several of you have signed up to stay on after the CLE today to take on a clinic case. Well, hold on, Aaron. It's not letting me. Sorry, can you just advance it?
Oh, I think you just did.
Okay.
Maybe.
Okay.
Yeah.
There we go. Good. Okay. So the clinic outside of today, which is an unusual clinic day post CLE, but typically it is held the second Friday of each month in the morning. We start off, well, I'll follow this in order. It's, anywhere from like 5 to getting close to 10 attorneys. We try to match up with 5 to, equal number of clients. They are pre-screened client files. So at this point, the client has filled out the application to GJP. We have pulled their GCIC, which is their official Georgia criminal history. They have gone through intake. They have gone through the case review team meeting, and we have decided that yes, we think they qualify for this, restriction and sealing and under Georgia law, and we think that this is a good clinic case. And our clinic cases, do range from administrative to filing pleadings, some court appearances for those hearings, but we do find that most of them are definitely pleadings, some pardon applications. And we've got a pretty good success rate of getting prosecutors to consent to orders before a hearing would be necessary. We do provide, I think it's a lot of support, and we are definitely willing to provide more support in any situations requiring it. But we provide template motions, we provide guidance, contacts for the prosecutor specific to your case, and all the GJP file via Dropbox beforehand. Let's see. So on the particular morning of the clinic, we do have a Zoom for the volunteer lawyers at 9 o'clock, and we do kind of a brief refresher because it could have been 2 hours or not even 2 hours, 2 minutes since you took the CLE, or it could have been a couple months. So we do a brief refresher. We're available to answer any questions about your particular client file because that would have already been sent to you via Dropbox earlier in the week. And then about 9:30, you call your client directly, and you're going to just continue gathering information about how their record has been a barrier. For those of you taking clinic cases today, we are going to do a little bit more Zooming with Aaron and me from 2 to 2:30 today, but then we've just advised your clients that you'll call them sometime in the next week. So it's not expected that you call them this afternoon. So similar to Aaron's email regarding intake, you get an email from me a few days before the clinic with the Dropbox link, with a template petition, the PowerPoint that we're going to go through during that refresher training. And we do have a volunteer agreement and understanding that's fairly common sense. Okay, so let's go through a Dropbox file for the clinic. And we are going to have 2 examples coming up, starting on, I think, the next slide. But there's that application to GJP that Aaron already showed you. There are the intake notes. There is their criminal history report, or their GCIC, that official Georgia criminal history. There is an engagement letter that we have asked the client to at least acknowledge beforehand, acknowledge their understanding and agreement. We used to have them sign those letters at the clinic when it was in person. With COVID, it was getting difficult to get the actual signed letters back, but Dominique has worked with the clients at this point in the timeline and has gotten verbal acknowledgement to that engagement letter. We do know that, especially those of you working for firms, that you oftentimes want to do a separate engagement letter, and we totally understand. I've done the firm thing before, and I know that's necessary, and conflicts checks and all that. We just ask that you kind of give your client a heads up, before they receive potentially a very lengthy firm standard engagement letter. So just let them know what to expect. Then also in the Dropbox file will be a specific checklist to your type of pleading. We do have, there are several types of pleadings that we use under Georgia's record restriction law to restrict and seal to the utmost of the law's ability. So there is a checklist that's specific that we hope makes it pretty straightforward what you're supposed to do when. And one other thing that wasn't listed in there, because sometimes it's there and sometimes it's not, is the disposition. That is the final court order saying that the person, was not convicted or that they were convicted. And the reason why it wasn't on that list is because sometimes it's there and sometimes it's not. And if it's not there, it's just a matter of getting it from the court clerk's office. And we'll also include that type of information in that initial email from me. So going through an example clinic file. Let me see if it pulls up for me or if I need Aaron to do it.
I can work on it, Molly.
Thank you.
Sure.
I wouldn't say we're the most technically savvy at Georgia Project. Okay, thank you.
Sure.
Okay, now let me see if I can scroll. Okay, so there are several documents in here. I'm actually going to start with kind of go in time order. So this is Mr. Doe's application to GJP. It's the same one that Aaron already showed you. Importantly for the clinic is his cell phone number and his email address. That is, your way to contact him. And then since Aaron's already gone through the rest of it, I will skip that for now. Then, well, actually, before I go back, this is, so he's a 55-year-old male. So I do think it's interesting sometimes, I mean, just to know a heads up of who you're talking to. And is this, we have a wide range of ages. I don't think we typically have any teenagers, but, somebody from their early 20s to people in their 70s and 80s. And for them, a lot of times it's either, a concern with getting housing, or, it's just the dignity, the shame of having a criminal history from something that happened so long ago. So after the application, we get their GCIC. So this individual, Mr. Doe, okay, I'm just going to show you a little bit more in depth, but Aaron's going to go even more in depth further into the CLE. So this is his criminal history where my cursor is. And this says cycle 1 of 1. So he has had only one arrest in the state of Georgia that he was fingerprinted for. So GCICs don't report minor traffic offenses. It's only if you've been arrested and fingerprinted within the state of Georgia that it would be included on this GCIC. So it's got the date of his arrest. So it's 30 plus years ago. It shows who arrested him, Atlanta Police Department, for theft by taking. And the case was heard in Fulton County Superior Court. So let's scroll on down, and then this, right here at the top of the page, it does show that he was found guilty of theft by taking. And then he did receive a pardon for that, but pardons have fairly limited benefit in Georgia. We'll get to that later in the presentation, but he, under a law that was revised several years ago, he is eligible for, I believe it's retro first offender that we're gonna pursue with him. So the retro, we're gonna petition the court to re-sentence him as a first offender. So but keep in mind that at the clinic stage, this will be very specifically laid out in my email from you, email to you. You know, your client is Mr. John Doe. You will file a retroactive first offender petition for his, February 15th, 1990 arrest in Fulton County Superior Court. Here's the prosecutor's information, etc. So they're the intake notes. We've already gone very into that, but that would give you already some pre-information that you can elaborate on in your clinic interview of Mr. Doe. The engagement letter, I'll show you this. So once again, we try to be as specific as possible. So GJP has agreed to assist you with, and it's got the exact type of pleading and the arrest date. So, if the client or you ever had any questions, you could direct the client right back to this letter that they had verbally acknowledged. It does say that the client understands GJP may enlist a volunteer attorney. Understand GJP cannot guarantee a particular result, those kind of statements. And then it gives some client responsibilities that they will provide accurate information, promptly notify GJP of any new charges, promptly notify of any change in address or phone number. So those kinds of things. And then we have them sign or verbally acknowledge. Okay. So the next thing I wanted to show you is the specific checklist for this type of pleading. So once again, oh, sorry. Let's see what I just did. Okay. So state of arrest, drafting the petition, we know that many of you, this is completely out of your wheelhouse. So we try to be as specific as possible. For retroactive first offender petitions, they have an unusual requirement. You've got to speak to the prosecutor first and obtain consent to file the petition. Then you file it, and this is what you include with the filing. And then what you do after it's filed and what you do after you receive an order. As a side note, because of our very thorough intake and review process, most of our clinic cases are cases that we believe the client, we wouldn't take the case or agree to take the case if we didn't think the client qualified for restriction and sealing. So, most of the time, the orders are granted either prior to any kind of hearing or after a hearing. So once that order is granted, you submit a letter to the jail to restrict and seal their records. We do work with a clearinghouse that called the Foundation for Continuing Justice, where we can upload the order to seal, and they put it out to the private background check companies to seal their records. Then you send a closing letter to the client, you submit our closing form so that we know that the case is ready to be closed. Then the other things, and I'm not going to click on it right now, I'll click on it on the next sample, but we do have the template petition in the Dropbox file in this example, as well as the template declaration, similar to an affidavit. And we do, that'll either be in your Dropbox file or in that initial email from me. So Erin, can you just flip me to Jane Doe's Dropbox file? Okay, so this is Jane Doe, and just, background information that we're aware of because of, her interview and such. She struggled with addiction in her life. She does have a couple convictions from that difficult period. And now she wants help getting a pardon. So similar to, to John Doe's Dropbox file, we've got her application. She is a 42-year-old female. I'll just tell you that. And so we're not going to click on that right now in the interest of time. but I will pull up her GCIC. Okay, so scrolling down for Miss Doe. So she has, it says cycle 1 of 2. So she has 2 arrests in Georgia. Cycle 1 is from 1995, and scrolling past the arresting agency part onto the court part. She has, excuse me? Sorry, I thought I heard something. Okay, she received First Offender Act. So that would be restricted or not available for a potential employer pulling a different purpose code of her GCIC. But scrolling down to this cycle 2, this is the one that we've agreed to assist her with. It's a 1997 arrest in Savannah for theft by shoplifting. And she was found guilty. And so for her, since she's already received first offender, that's a method or that you can only use one time. So she wouldn't qualify to petition the court for first offender. So her, because this is in, well, for some reason, I think, yes, it's in Superior Court and she had probation for 3 years. So we can assume that this was a felony. And so her only, I guess, recourse or ability is to submit a pardon application. So that is a kind of lengthy application. It very detailed questions. I will show you the application. And I will just summarize the intake notes. She did report that she had, her criminal record had been a barrier to employment. And also she had gotten her real estate license, or she was attempting to get her real estate license, but she was prevented from getting it because of this felony conviction on her record. So those are the things that we're trying to assist her with. So again, there is the engagement letter up here. Again, it would say, you know, that we've agreed to assist her with a pardon application for this particular arrest. It's got the checklist down here. And then it's got the application. So, and we do ask, I mean, with the pardon application, you know, it does require a little bit more preparation on, well, it requires a lot more preparation on the client's part and also on the lawyer's part. But for those lawyers that are not licensed in the state of Georgia, either because you're retired or you're licensed outside the state and you work for a corporation in Atlanta or Georgia, or you're a paralegal, this is, pardon applications do not require a lawyer. So this is where we are able to use those legal volunteers that are not licensed in Georgia. So the application, I will not go through all of it, but it's 15 pages. It asks for, you know, your contact information, marital situation, children, the full address of each place you've lived in the past 10 years, education. It also goes into financial information, whether you're in any type of debt, certainly employment information. It also asks about any substance abuse, or it's just very, very thorough. And we do put together a packet of information. So not just this application, but also we include character reference letters typically, and any kind of you know, rewards or not rewards, awards, or community involvement, or you know, any diplomas or transcripts of kind of the good stuff that they've been doing since they were arrested and convicted. So that's Miss Doe. Does anybody have any questions about these two kind of case studies before I move on to a couple more clinic slides? Okay. Erin, can you get me back to the slide?
Yes.
Thank you. Thank you. Okay, some frequently asked questions. What if I do not practice criminal law? Do not worry. We have very few actual criminal defense lawyers that volunteer with us. The vast majority of our volunteer lawyers practice corporate law, real estate, employment, some litigators, but we understand, and Erin and I say a lot, we're able to help you as much as you want help. We certainly don't want to micromanage, but to the extent you have questions, we are always available. And if it is your first hearing and you want us to go with you, or if you want us to, walk through kind of some hearing prep beforehand, we are happy to do that. Again, if you don't work for a firm, or if you're retired, taking some time off, what have you, you can still take a case, but it would need to be a pardon application case, or another type is called a record restriction application. And those two do not require licensed lawyers. We do if anybody's concerned, we do provide malpractice insurance for our volunteer lawyers. Thankfully we've never had to use that. We've also, as far as conflicts checks go, I think we've had this clinic for almost 8 years, and there's only been one case where the volunteer felt they couldn't proceed with the representation because of a potential conflict. Sorry, I'm trying. Okay, there we go. Will you have to pay any fees or expenses? Probably no. None of the court filings require filing fees. You may have to pay $1 or $2 to get the disposition, that final court order, or if it is one of the record restriction application cases, there is oftentimes a $25 processing charge. Of course, if you work for a firm and they want to pay that expense out of their pro bono budget, we really appreciate it as a nonprofit, but we also have limited scholarship funds at GJP that we could use. If there's not a disposition in the file, you're going to need to contact the clerk's office. And do you need to explain to your client which cycles are eligible? No. We've already told them through the appointment process and the engagement letter process what cycles we're assisting with. Again, if the applicant has an urgent matter, we are here to help, but this is very rare. And, I guess to give an example of this, it could be that, employment situation where there's an offer on the table that's going to go away, or it could be the being evicted, or occasionally, it could be a mental health issue. But if there's ever a situation where you need to ask us a question or get our help, we are here. Again, if something comes up, we know it happens. And I will say sometimes it happens on our clients' end too, their employees, their mothers and fathers. So just to be understanding if for some reason the client isn't responsive right when they're supposed to be. But we do count on you. When you sign up for the clinic, we do schedule the number of clients based on the number of lawyers we have that have signed up. So it does require some juggling on our part. So to the extent you can give us as much time as possible, heads up, that'd be great. How to be an outstanding clinic volunteer. This is common sense. And, I hope it's common sense. And I hope that these are skills that you use with your paying clients, your billable clients. But, please respond promptly to your client, to GJP staff. Just like if you were in person, you would likely hand your client a business card. Be sure when you're talking to them on the phone that initial time, give them your email, your office number, whatever way is best for them to reach you. If something comes up and a case you've been waiting to go to trial, all of a sudden it's been scheduled and that you were not going to do anything on this case for months, let us know. It's very disheartening when nothing's been done on a clinic file, and I have to call that client and let them know that nothing's been done. Work on your case in a timely manner. On average, they're about 10 to 15 hours of work. You've got the template pleading. You're based on your interview and based on the intake notes, you're putting in information about how the client's record has been a barrier to them. So with that said, one of our longtime volunteer lawyers, Jolanda Herring, was not able to participate on the CLE today because she's at an all-day conference in Lake Lanier, but she did do a video recording for us to share with you today. Before we start on that, does anybody have any questions? Okay, thank you.
Greetings, everyone. My name is Jolanda Herring. I'm an attorney here at Hollowell, Foster & Herring in College Park. I've had the pleasure of volunteering with the Georgia Justice Project since December of 2020. I've been asked to share some of my experiences as a volunteer attorney with this wonderful organization. I've served both as a volunteer intake coordinator as well as a volunteer attorney. As an intake coordinator, I conducted preliminary interviews to determine whether or not the candidates met the threshold requirements under the statute. I've also provided legal representation to a number of individuals who were good candidates for petitions to restrict and/or seal their criminal records. Currently, I've been able to obtain restrictions for 100% of the cases that I've been assigned. Fingers crossed. I want to be clear that I'm absolutely not a criminal attorney. For the past 15 years, I have practiced here at the firm in the areas of corporate transactions, employment law, estate planning, federal contracting, and general litigation. While I enjoy my work, nothing has been more fulfilling than providing much needed assistance to those who have made mistakes and who are restrained by their criminal record from moving on from those mistakes. As the proud daughter of 2 ministers, I have always had a strong sense of community. By that, I mean the community as a whole, which includes everyone. In collaboration with the Georgia Justice Project, the Georgia legislature passed significant legislation that allows individuals a chance to move on from their past mistakes. I'm not talking about career criminals with no intent to do better, but people who, for whatever reason, made choices that they now regret and choices that keep them from obtaining good jobs, decent housing, and the dignity they deserve. As part of the broader community, I've been humbled to assist my fellow citizens with the opportunity to move forward. I want them to move forward much more optimistically into their futures. Working with the Georgia Justice Project has been a refreshing experience for me. All of the staff work very hard and they're committed to the mission. But most impressive, they really care about the individuals who seek their help. I encourage each of you to consider volunteering with this organization. I can assure you that you will learn a lot. You will gain a better understanding of the world you live in. You might even develop a little more compassion as you begin to understand other ways of life. And you'll also do like I did. You'll meet new friends. My experience with the judges at the hearings has been unparalleled. For someone to return to a judge that sentenced them, to now be praised at doing a good job and moving forward into their future, that is such a rewarding experience. As much for me as for my clients. The Georgia Justice Project allows me to do my part in the community that I love. I understand that creating opportunities for better jobs and education actually make our community better. To quote Brian Stevenson, each of us is more than the worst thing we've ever done. Thank you very much.
Okay, great. Well, we just wanted y'all to hear it from the horse's mouth about volunteering with GJP. So hopefully that was insightful. And now we are going to do a deeper dive into criminal records and the law around criminal records. So I just want to give a little disclaimer that we have had the feedback that this part can be a little intimidating. And I'm going to go pretty quickly through this information because keeping in mind that, you know, for the volunteer experience, you don't have to have all of this memorized, right? So just want to say we're going to give you the info, but don't be scared. So we find it's helpful if we're all using the same language when we're going through this information. So when we're talking about the world of backgrounds and criminal history reports, we really want to keep in mind that there are two sources of information. The first is the GCIC reports. So you've already seen a couple of examples of those. And that is the official record. It is maintained by the GBI through the GCIC, the Georgia Crime Information Center. It's important to keep in mind that there are different levels of access to the information in this database. So law enforcement, prosecutors, folks like that have the deepest level of access to the information. But the other world of background checks that we want to keep in mind when we're thinking about record clearing are private background checks, because that is actually what most employers and landlords are going to be using. And they do not, the private background checks don't get their information from the GCIC database. They pull their information from anything that's considered a public record, so from court records. These companies are like HireRight, ADP, Sterling Infosystems, Checker, Experian. Those are some of the bigger names, but there are literally hundreds of these companies operating in the US. So it's important to keep that in mind. Expungement, you might hear us use the word expungement. That is the term that most people are familiar with. But really, when you're getting technical, expungement refers to the record being totally eliminated from somebody's criminal record. And technically, Georgia doesn't do that. They don't actually eliminate the records from the GCIC database. What we have available to us is called restriction and sealing. So restriction refers to limiting access to the information on the GCIC report. And sealing, in most cases, refers to limiting access to the court records. And when we're thinking about record clearing in Georgia, we really want to think about both of these things together. The law says that you have to start with restricting access to the GCIC information, but we don't want to stop there because we know that most employers and housing providers are going to be getting that information from the courts anyways. So we want to take that next step of sealing the court records in most cases. Pardon, you've already seen a little bit of a pardon in the example Jane Doe clinic file, but a pardon is a certificate of forgiveness from the state. And what Molly mentioned earlier is that a pardon alone doesn't clear or restrict and seal the record. If somebody is granted a pardon, a notation will be made on their GCIC report. But a pardon is much more powerful now because that is the only avenue in a lot of cases for a felony conviction to be expunged from somebody's record. So part of what SB 288 did was create a pathway via a pardon for folks to get their records expunged. And we talked a little bit about first offender, but that is Georgia's second chance law. And basically what it says is that if somebody pleads or is sentenced as a first offender, once they complete the terms of their sentence, it is not considered a conviction. It's what we call a deferred adjudication. All right, so just diving a little bit more deeply into these two types of background checks. So again, I think we've covered most of this information in the last slide, but just want to go over again, I think this visual of the two, we want to keep that in mind. When it comes to GCIC, so it is this big collection pot of information. There's over 1,500 different agencies that have the ability to put information into the GCIC database. GCIC is not going out there searching for the information. It is a repository, so they are waiting for other agencies to put the information in. So again, it's called restriction when we're thinking about clearing the record, the GCIC record. So we want to keep in mind, the different levels of access. And the way that somebody's criminal history starts is when they are arrested and fingerprinted for an offense. So if you get a traffic ticket, not that that's ever happened to me, but if it did and you're not fingerprinted, you don't have a criminal history. You may have driver history. Those are separate records maintained by DDS, Department of Driver Services. It's only really at the point of fingerprinting that a criminal record is created. So again, we're going to keep in mind those different levels of access to the information in GCIC. And you can tell what type of level of access you're looking at by the purpose code listed on the GCIC report. So we're going to go through an example GCIC here in the next couple of slides. And so you'll get to see what that looks like. As you can imagine, with 1,500 different agencies putting the information into GCIC, there is room for error, right? So we do see mistakes. We see a lot of missing information as well. And then for the private company reports, again, those are pulling records from the clerks and from jails. These companies are regulated federally under the Fair Credit Reporting Act, or FCRA. And there are some, rules regarding what information and what rights folks have under the Fair Credit Reporting Act. So I'm getting a question, does GJP take cases to petition to correct a report if there's an error? Absolutely, yes, we will help folks clean up or correct a mistake on their report. And that example that you noted is one that we see quite frequently, where somebody might have a crime reported as a felony, but it's actually a misdemeanor. And we all know, having that label of a felon can be quite a barrier. So we definitely try and assist those folks when we're able to. While we do see mistakes on GCIC reports, we also see a lot of mistakes on these private background check reports. They have a higher error rate. So that's something to be aware of as well. Okay, we're going to go into the next slide here, which is how to read a GCIC report. So one skill that you develop as a volunteer is reading these becomes a little bit like a second language.
And
So,
Erin, just to interrupt real briefly,
sure.
if you all got in the email that Erin sent you with the link yesterday, there's a PDF GCIC report if you want to. I think it's the same one that she's about to go through.
Yes, thank you, Molly. Great point, because I'm going to show you the next slide, but of course, depending on how you're viewing the Zoom, it might appear teeny tiny on your screen. So please feel free to minimize Zoom and go to that PDF that I sent you yesterday. So this is what the first page of a GCIC report looks like. Hopefully this looks a little familiar now that we've looked at a couple of them, but just want to point out some highlights here. So I'm going to use my cursor. Hopefully y'all can see this. We need to have one that's highlighted, but we don't. So up here in this area is where you're going to see that purpose code. So the most common that you're going to see in your work as a volunteer with Georgia Justice Project is either a purpose code E, and that I think of as the employer's level of access, E for employer or housing provider, or a purpose code U. So a purpose code U is an individual's level of access to their own criminal history information. And that is typically what we like to see at GJP, because it's going to give us a broader picture of the record than what potentially a purpose code E might have on it. So this part we do have highlighted. So down here, there's the identifying information. So you're going to be able to see any names that are associated with an individual. They have, we have alias listed here. Sometimes there are actual aliases, but quite often they're also just like a misspelling of somebody's name. So again, thinking about that error rate and the 1,500 different agencies, if an officer writes somebody's name down wrong and puts it in GCIC, it's going to show that way. And you'll also be able to see the date that the information was entered. And you'll get other biographical information, like their social security number, their birth date. I will say that we are trying to redact these when we send them virtually. So you may have a redacted copy in the Dropbox files that you get, because we're trying to be mindful of security of clients' information. And then moving through the record, you can see that in the sort of upper middle part of the page is where the record itself really starts. So you're going to see the number of arrests. Now we tried to pick a pretty simple one here for our example, but it will say cycle 1 of however many arrests there have been. So 1 of 1 right here, but it could be 1 of 10. And then you'll know that second number is the number of arrests in the total report. So some of the highlights that we like to note is the date of the arrest, the arresting agency, and as you're going through it, you'll be able to see the charges, the outcome of the charges. This is really important, and this is where there may be missing information that we're going to ask you to ask either the applicant or the client to help fill in for us. So if this information was put into GCIC, it'll appear here. And then the sentence, if they received the sentence. You'll also note that, in each block of information, you can see who put that information into GCIC. And every agency will be listed here at the back in this index. So any agency that put information in or was involved in that arrest or court case will have a number that you can correlate to back in the GCIC. So keeping in mind that, we are going to be using this word restriction to refer to when a record has been, removed from that public access on GCIC. But I just want to make a note that sometimes you'll see something that says time expired restriction. I really wish I would have come up with a different word for this, but that's what they've chosen to use. So this, I really think of as like an impermanent restriction. It does not mean that this cycle will be restricted forever. All it means is that somebody did not put the information about the disposition of the case into GCIC. So there are 3 possibilities. It could be that the case is still pending. It's probably unlikely, but it's possible. It could be that the case resulted in a conviction, or it could be that the case resulted in a non-conviction. GCIC will enter these time expired restrictions as a temporary restriction, and it happens after a set amount of time. So for misdemeanors, if no outcome is listed after 2 years, this time expired restriction will go into effect. For most felonies, it'll happen after 4 years. And for serious violent felonies, it'll happen after 7 years. Okay, so what can be done in Georgia to clean up a record? What are the remedies available to folks who have a conviction? So again, I'm going to sort of fly through this information. Just want to reiterate here, we have no expectation that you will have this memorized, but we want to give you sort of the big picture, the context of the work that you're doing. So the first remedy that we always look for is the person eligible for first offender. Even if they didn't take first offender at the time of sentencing, the law now allows them to go back to court and petition the judge to give them first offender on an old case. So that's called retroactive first offender. If folks were eligible at the time that they were sentenced, then they can go back and petition the court. We have a relatively new law called the Survivors First Act, which we at GJP were not involved in implementing, but it is a very powerful record restriction law that is available to folks who are survivors of human or labor trafficking, sex or labor trafficking. So we're going to talk a little bit about that. If you have a felony conviction or certain misdemeanor convictions, you may be eligible to apply for a pardon and then ask that a pardon case be restricted and sealed. And of course, now under SB 288, we have greater eligibility to restrict and seal misdemeanor convictions. So we're going to go through these one at a time. So again, first line of attack for us is this person eligible for retroactive first offender? So again, this is so powerful because it actually changes a conviction into a non-conviction. That is the statute. If anybody wants to go and look it up, you have the citation right there. So in order to be eligible to request retroactive first offender, someone cannot have used first offender in the past. We have to show that they were not informed that they were eligible to ask for first offender at the time that they were sentenced. It can be really pretty tricky to prove a negative like this. Like, how do you show somebody wasn't told something? So usually what we do, and Molly mentioned this in the demo files, but we usually, for almost all of our petitions, but definitely for retroactive first offender, we include a declaration or an affidavit from the client stating, I was not informed. We'll also sometimes include or refer to the transcript of the plea hearing. So we can show that, look, judge, read through the transcript, no one ever mentioned first offender. My client is saying they weren't informed. That's what we do to meet that requirement. They can't have any prior felony convictions, and we have to show that they would have successfully completed first offender. So this remedy is really best for felonies or for misdemeanors if they're eligible. So, who's a good candidate for this? Somebody who maybe only has one felony conviction or one misdemeanor conviction or some sort of outlying charge. There are certain types of cases that are not eligible for first offender. Those are excluded offenses. And those include serious violent felonies, certain sex crimes, elder abuse, abuse of disabled persons, child pornography, certain crimes committed against law enforcement, and DUI. So again, you do not have to keep this all in your brain. GJP is screening for all of these eligibility requirements. So if you are a clinic volunteer and you get assigned a retroactive first offender, to the best of our ability, we have determined that the client is eligible. Okay. So once somebody is granted first offender or retroactive first offender, sealing is possible under this portion of the statute. And it's really important that we try and seal those cases, even though, once they get first offender, it's a non-conviction. We want to just make sure that the records get sealed so it's not reported on a private background check. And this portion of the statute says that employers cannot use a first offender case when considering someone for employment. There are a few exceptions to this. So if somebody has certain types of convictions and they're applying to work with children or disabled folks, in those scenarios, the employer would be able to see the case. But almost every other scenario, the employer is not allowed to use a first offender case. One thing that's a little unique about these retroactive first offender petitions, and we talked about this in the demo file, is that right now, under current Georgia law, we have to get permission from the prosecutor before we can even file a petition. As far as we're aware, this is pretty unique in the law. In no other arena does the prosecutor really hold the keys to the courthouse door. So just something to be aware of, that if you get assigned one of these cases, before you can file, you have to have a conversation with the prosecutor getting consent to file. So the other thing that we're screening for when folks come to us asking for assistance is to see if they might be able to take advantage of the Survivors First Act. This is a really powerful record clearing law that is available to folks who are survivors of, like I said, sex or labor trafficking. It's so powerful because if a conviction happened as a direct result of that person being a survivor, the conviction can be vacated, basically meaning overturned. So again, a conviction would become not a conviction. And then the record can be restricted and sealed. even if the conviction didn't occur as a direct result of the person's, being a victim or a survivor of trafficking, if it just happened during the time that the person was being trafficked, the records can be restricted and sealed. So in order to be eligible for this, somebody can't have any outstanding warrants. If it's a felony conviction, 1 year has to have passed since they completed the end of their sentence. If it's a misdemeanor conviction, it's only 6 months from the time of being sentenced. So much shorter waiting period there for a misdemeanor. So these are unique. You file them in the court that sentenced the person. That part's not unique. But what is unique is that you have to use a special form that was created by the Attorney General. And there is only a hearing if the prosecutor objects. If the prosecutor does nothing or consents, the law says that the judge has to grant these. So that's really powerful. Okay, I'm getting a question about what do I mean when I say employers can't use the retroactive first offender conviction. So does that mean that employers can't see it or that they cannot rely on it to deny employment? It should be both. Employers should not be able to see it, and that they should not be using it to deny somebody employment. So hopefully that clarifies a little bit there. Okay, I want to talk quickly about pardons. So again, this is that order of official forgiveness from the state of Georgia. In Georgia, they're granted by our State Board of Pardons and Paroles. They can only pardon Georgia conviction. The exception is if somebody is asking for their firearms rights to be restored. Pardons are typically for felonies. Sometimes they are available to misdemeanors. Somebody has to qualify for an exception. A star here noting that the record would remain publicly available if somebody stops at the point of getting a pardon. But now, if you receive a pardon, you can go on and ask for it to be restricted and sealed. A pardon alone does offer some negligent hiring protection to employers. So it is attractive to employers, on its own, but really now now that folks have the ability to get the record expunged, we really encourage them to go ahead and do that. In order to be eligible for a general pardon, which is what you need in order to later seek expungement, you have to have 5 years since you've completed the terms of any sentence. You have to be able to show the board that you've lived a crime-free life. So essentially no new arrests or convictions. You have to have paid any fines and restitution in any cases and no pending charges. So for these, it's not a pleading, it is an application. Somebody fills out an application or has one of our wonderful volunteers assist them with applying for a pardon. As Molly mentioned, these pardons are quite extensive, but I do just want to give a little context. The board does grant these with some regularity. We just saw the latest annual report from the board, and they generally grant about 500 of these a year. So, and it is a lengthy process. Not only is the application itself lengthy, but then the board does an entire investigation on their own, and that process, they say takes 6 to 9 months, but we're really seeing that it's more like 9 to 12 months right now. All right, so once somebody's gotten that pardon, we are going to encourage them to seek restriction and sealing of that case. So again, this is a provision that was part of SB 288, started in January of last year. Someone can obtain a pardon for any type of offense, but certain offenses that have been pardoned are not eligible for expungement. So those are going to be those serious violent felonies or serious sex offenses. So the process for this is to file a petition in the court of original jurisdiction, and it is discretionary. So the judge can say yes or no. All right, so the remedy that's available for folks who have a misdemeanor conviction is to file petitions to restrict and seal. And again, this is part of that SB 288 law. So I just want to talk a little bit about who is eligible for this. So somebody cannot have any pending cases and no convictions in the 4 years prior to applying. It does have to be an eligible offense, and not all misdemeanors are eligible. Mostly when I think about which ones are eligible, it's everything except most thefts are not eligible, unfortunately. Theft by shoplifting is eligible, and refund fraud is eligible, but any other kind of theft is not eligible. And then any sort of misdemeanor sex case or DUI. If someone was convicted for family violence battery, they are only eligible for restriction and sealing if they were under 21 years old at the time that they were arrested for that offense. This is a petition-based process. So again, it is really helpful for folks to have an attorney representing them on these petitions. And again, it's discretionary, so the judge can say yes or no. The law does impose a lifetime limit of 2, meaning that somebody can request restriction and sealing for up to 2 misdemeanor convictions. And again, Doug mentioned the incredible employer protections that are available to folks now. So a little less commonly, but not much, is that folks will come to us and say, I have this arrest. I was never actually convicted of this offense, but it's still been a barrier to me. Employers can often, and landlords can often still see this information. It may be online. And most non-convictions are eligible to be restricted and sealed. So we're going to talk about that. So the first step, again, you're always going to want to go to that restriction of the GCIC report. And here, the process will vary depending on when the arrest was. The restriction law was enacted July 1st of 2013. So the legislator said, okay, everybody before this has to go through our old process. Everybody after this, though, we're going to do it automatically. So for arrests that happened before July 1st of 2013, the person has to apply for restriction. It's a pretty simple application. We will often just ask folks to do this process on their own. And we have, for those that are occurred after July 1st of 2013, we have should in quotations here, because unfortunately this is not being implemented across the board, and not all of these are being entered into GCIC. So we will assist folks who have an eligible restriction, but it has not been entered. It's the types of dispositions. I'm just going to go through this list here. Again, you don't have to have this memorized, but if the case was not forwarded for prosecution. Do I have a question? No, okay. If the case was not presented to the grand jury, it'll say NPGJ'd. It might say no billed or dismissed or null prost. It might say acquitted. It might say reversed or vacated, very rarely. So those are the types of dispositions that are eligible. And the next step, again, we're going to always want to think about sealing the court record. So the process for sealing is that you always have to file a motion in court. It is always discretionary. The judge is undertaking a balancing test, trying to determine if the harm to the client's privacy is outweighed by the public's interest in having the records available. And the way that we typically try to meet our burden of showing that the harm is, outweighs the public's interest is explaining to the court all the ways that this record has been a barrier for the client. So they've been denied jobs, they've been denied housing. This might sound familiar from the type of information that is gathered during those intake appointments. Okay. So I'm almost at the end here. So it is possible too that somebody may have actually taken advantage of first offender when they initially went to court. And maybe they did that process, but the record is still showing up for them, and there is something that can be done for these. So if somebody was previously sentenced and successfully completed the terms of their sentence, the case should be discharged. That's the final step of a first offender case. And once that discharge happens, sorry about that, it will appear as sealed on GCIC. I hate that GCIC has chosen to use the sealed language because it's confusing, I think. It does not mean that the court records have been sealed. The sealed first offender is essentially the same as a restriction. And then we're going to want to think about, asking the court records to be sealed. One thing that's interesting to note is that we can actually ask for these records to be sealed at the time of sentencing. That's not anything that you all are going to be doing because you're not going to be working on our criminal defense cases. So really, this will be, prior or after the case has been completed. We also see these cases that are put on the dead docket. This is a really interesting method of essentially putting the case on the shelf, where the prosecutor, for whatever reason, says, I'm not going to go forward with prosecuting this case right now. Oftentimes it's, I want you to complete a set of conditions, right? Do 100 hours of community service, complete a pretrial diversion program. When you can come back to court and show me that you've done that, I'm going to take the case off the shelf and dismiss it. Unfortunately, especially in Metro Atlanta, we see that that last part doesn't always happen. They don't actually take the case off the shelf and dismiss it. So this is technically an open case and can be appearing on background checks. Folks can petition to have them restricted and sealed after they've been on the dead docket for 12 months. There are certain circumstances where we're going to ask that it be dismissed first before it gets restricted and sealed. Again, it is a petition-based process, so we're going to file those in the court of original jurisdiction. Okay, I'm 2 minutes over, but not too bad. For these last couple of slides, I'm going to give it back to Molly to walk us through.
Okay. So just a couple kind of follow-ups about other things that are related to criminal records. So a lot of people think if you've been arrested, convicted, that you can no longer vote. That is true while you're under probational control or under correctional control, but it is, you can vote once you are off paper, once your probation and all your fines or any other requirements imposed by the court have been completed. And you do have to go through kind of the voter registration process, but this is really important for folks to know. Then, oh goodness, hold on. Trying to get to the next slide here. There's a little, okay. So policy priorities this year, and you should have all received a one-pager about our GJP's legislative priorities in the email yesterday. So the 3 areas we are most focused on is that occupational licensing, reducing the driver's license suspensions, and expanding access to expungement. We have made good progress so far this legislative session, and we're hoping that we can kind of cross the finish line on all 3 of these. For the occupational licensing, there are 50 licensing boards in the state of Georgia, all with different standards. So oftentimes it's not clear to a client that, how, if they are denied a license, how to appeal or what rights they do have under that denial or as subsequent to that denial. It's also really overwhelming and discouraging to some of our clients who want to apply for a license, have done whatever training, certification that's necessary, but they just get so discouraged that they don't move to that next step, which would enable them to, possibly get more of a full-time job or a higher paying job with that license. The driver's license issues, there is, if you are ever a failure to appear for missing a court date for any traffic violation, it automatically results in a suspended driver's license. So there are over 100,000 driver's licenses suspended every year in Georgia because of this reason. And in Georgia, especially in the metro Atlanta area, even with MARTA, most of us drive to and from work. And almost half of the people who lose their driver's license end up losing their job because they can't get there. And then that just leads to a black hole or a cycle of deeper poverty, fines, arrests, decreased ability to pay a court debt, and a lot of barriers trying to reclaim the license. Then that last one deals with expanding access to expungement. So Erin, when she was talking about the petitions to restrict and seal misdemeanor convictions, right now there are some theft charges are excluded, not theft by shoplifting, but a few others. So this bill, which is SB 457, would I guess equalize or eligibility for some misdemeanor convictions to not be excluded. It would also take away that requirement to get consent from the prosecutor before filing a retroactive first offender petition, and it would also automate some of the felony petitions to restrict and seal pardoned felony convictions. So those felony convictions that have already been pardoned. So those are the items that we're working on right now. If you're interested in getting involved, we still are going through the legislative session. So we'd love to get your voice and your voice contacting your legislators and letting them know that these issues are important to you, important to your community. Okay, so right here on the left, if you would like to sign up for intake, we hope you have been inspired, motivated, not overwhelmed. It is a lot of information, but we really do bring it down to all you need to know for intake or for the clinic. As a reminder, intake is every Thursday morning, and that is interviewing and taking those intake notes for potential clients. Clinic is taking on a client for direct representation, pending any conflicts checks, what have you. And that's held the second Friday morning of each month. And for some of you, right after the CLE today. Here is Erin's and my contact information. We are always here to answer any questions if you have any concerns. We definitely want your feedback on today, the good, the bad, the ugly, because we do host these CLEs about 3 times a year. Whoops, sorry, I didn't mean to push that button. Okay, we do have corporate supporters at GJP. Upcoming, we have our annual event to thank our supporters. They're listed here, some law firms, corporations. If you'd like to be a supporter, let us know and we will put you in touch with our development director. But we thank all of these folks. And we appreciate it. Erin, did we have a survey we wanted to circulate?
Yes. Let me see, Molly, I'm going to take back control here.
Okay.
Or try to, and I actually have a couple of links I'm going to put in the chat. So let me see. Okay, so a couple of links I'm going to try and put in the chat, and I'm actually going to stop sharing now. Hi, everyone. Okay. So let me get to my links. I have a couple of things, but maybe while I'm doing this, if you all have any questions for us, now is the time. We have a few minutes here before we're going to take a quick break before the clinic. So please fire away questions and I'll try to put these links in somewhat quickly.
I will say thank you very much to everyone who, whether you were just looking for some CLE credit or your boss suggested you attend today, or you're interested in participating in intake or the clinic.